Hamilton Road, cross streets of Douglas Road and Brandon Road. It's going to be a sick call, reference to vomiting, 26 out. Hello, 13 jurors. Sorry, I'm listening to the scanner. Sorry. I'm listening to the scanner and I didn't want to miss anything about the shooting. We're still waiting to see what's happening with, I'm listening to the active shooter scanner from North Carolina. So anytime they say something, I'm trying to listen and make sure that we can find out what's going on. All right. So, hello, 13 jurors. Hello. Welcome back to the internets. It has been, I'm going to take these off for a second so I can hear. It has been a lovely few days, but now today everything is going haywire. I am listening right now, as is Lucy, but you can't tell because she's a little bit more chilled out than I am. I am listening right now to the scanner. So they have, I tweeted this out. So I have a scanner on my phone, and so I get notifications when, big stuff is happening, so we can kind of make sure that we're on top of things and know what's going on. And I am listening now. I had tweeted it out earlier, but I got a notification that there was an active shooter near University of North Carolina, Chapel Hill. And so I pulled it up and I tweeted out the link where they were saying Orange County Fire and EMS active shooter. And so I was listening and they said suspect in custody. And I was like, oh, this is great. And then it turns out it wasn't the right suspect in custody. So I've been trying to listen to see what else is going on and see what I can hear about everything. When I tweeted it, there are a few people who were posting on my Twitter that, they had kids there and stuff like that. So I'm trying to listen and see what we can hear. So when I heard them say suspect in custody, I was like, this is great. Like that was fast and they got it taken care of. And now it's the wrong suspect. So now we're just waiting to hear, hopefully good news and not, the world is going freaking nuts, y'all. I see some of y'all, you can see how I'm a little bit sunburned. I've been out in the sun all weekend on boats all weekend, which was amazing. I got to spend some good time with my family. I got to spend some good time with my friends, but I am just a little bit sunburnt, mostly on my chin because I had a hat on and stuff. So my hat, so it's really just kind of like just the chin, for like the reflection off the water got my chin a little sunburnt. But other than that, so if you're wondering why my chin looks bright red, it's because it's sunburnt. And I saw some of y'all asking about sorry, I don't want to miss what they say about it. saw some of y'all asking about the hurricane. I am okay as far as the hurricane goes as of now. It's a beautiful, beautiful day out there today, actually. But I know that, it's supposed to be coming, but it looks like it may have shifted east enough to where I'm out of the line of fire. But they can always, they have minds of their own. They're like children or dogs. They have minds of their own. So I will keep an eye on it, and we will watch and see what happens. So for the trial that for the for the trial that we have coming up, I had pulled a few things for it. For some reason, it's not letting me access most of the court documents. I can pull up like the court filings and stuff, but not the actual documents. But I have enough of it to where we'll be able to go through it. Now, I will tell you, this one is a sad one. I mean, not that any of them are just nothing but fun, but this one does involve a 13-year-old girl, and it's a little bit of a mess. So I'm going to turn off the scanner for now because I'm not going to be able to get anything out because I'm going to be so focused on trying to hear it. We'll check again for updates as soon as we're done with our stream. We're not going to do a real long stream today unless they start. I don't foresee them starting today. They had not picked a jury yet, and they were coming back from break at 3:00, which is about half an hour ago. So I don't know if they will have a jury today or not. But they might be starting tomorrow. But I wanted to do at least a little introduction stream so we know what's coming up and so we can see each other. I took Friday off to spend time with my family. So, we haven't seen each other in so long. I needed to see my jurors, tell y'all about this and about some other stuff coming up. So, all right. Before we get started on this specific trial, I don't know if y'all saw it or not. I had put it on the podcast website, and I think I put it on Facebook the other day, but I don't think I've tweeted it yet. I've been doing the podcast episodes for I did them for Thami, old Thami, and and people seem to like them. So I've been wanting to do a deep dive podcast, and the one that I'd planned on doing it for my friend's murder, they are in the process of, they're about to be going through an appeal. So their attorney has asked that I hold off on that one because there's some stuff that would be coming out that they don't want the state to prepare for. So, and I am all about, y'all know me, I would much rather have justice than clicks and likes. So I can hold off on that one, make sure we're doing the best thing for everybody involved. So I've got some stuff for that one, but we're going to hold off on that one. But because of that, I don't know how long this appeals process is going to take. And I don't want to just wait, and not do anything else. So I've been wanting to find something that I could do a deep dive on. And then all this stuff with Karen Reed has been happening, and everybody's been sending stuff to me about it. And the more I've kind of dug in, the more I've gotten lost in it. So I will tell you, let me pull it up. I am going to me show you. Here we go. I am going to be doing a podcast deep dive on Karen Reed. So it's going to be called Conspiracy in Canton, the controversial case of Karen Reed, coming soon. So this is going to be the newest deep dive. PJ, I completely understand. We are here for you when you want to pop in. Yeah, the next one, the trial that we're about to do, I don't expect it to be a very long one. But I know that it will be a tough one for some. So if you're able to watch it and want to watch it with us, fine. If not, we will catch you on the next one. I know anything with kids and anything with, I mean, anything with kids, like I have a hard time with it too. So, but if this one ends up being too much, then feel free to pop out and just hang out with us later. All right. So the Karen Reed thing is going to be the next podcast. Now, I have talked to a few people who have already done a lot of work on this, and kind of talking to them about, some of the, just some of the craziness that's going in with this one. One thing that I've noticed as I'm going through a lot of stuff is there are some people who report on stuff and it's, very factual. And then there are some people who report on stuff and it's very opinionated and it leaves out certain facts that do or don't go toward what they think is what's going on. So if they think that, she's guilty, then they'll leave out specific facts. Or if they think that, she's being framed, then they'll leave out specific facts. Not everybody. There are a couple that I found who I thought, did a great job of reporting everything, even if they're very opinionated about which side of the, trial they land, or which side of the case they land on. There, they might be very opinionated about it, but they are still very good at reporting facts, which is my biggest thing. So I am weeding through a lot of opinion stuff. I'm weeding through a lot of fact stuff, but this is going to be coming soon, and I'm going to do like one episode per week, and we're going to follow it. So I am excited to see what comes of this one. There's a lot that I'm still sifting through on this one that we're going through. If you were with us, what was it, Thursday? While we were on Verdict Watch, we watched one of the hearings, the pretrial hearings for this, and it's just crazy. So, so I'm excited to get it started. Now, the one that we're doing today, let's see. Oh, there's a new note. Court is back to jury selection right now. It will probably start tomorrow. It's already 3:30. They're not going to have time for opening, so it will probably start tomorrow. But that's okay. We'll do a short intro today, and that way you kind of know what to expect and what's going on. And then we will keep an eye out and for when it starts. And start tomorrow. All right, let's see. Okay. Karen Reed it's in the Boston area. Like Boston, Massachusetts area, but it's like Canton. All right, so there's all right, so this is the stuff. My eyeballs are blurry. Let's see. Let me get on my old lady glasses. And actually, yesterday my friends and I, we took a tiki boat out from my friend's birthday, and It was so cool. If y'all have never heard of like the tiki boats or done the tiki boats, they are a lot of fun. It's literally like a floating tiki bar, and you have a captain / bartender who just drives you around the water, and then you stop and swim and stuff. And it was so much fun. But he had this like Boston accent, and I was like, where are you from? And like, Friday, I'd spent a lot of my day Friday, working on getting a lot of this stuff situated. So I'd had like Boston on the mind anyway. So I saw, or I heard his accent, and I was like, where are you from? He said Massachusetts. I was like, that's my sign that I'm doing the right one. I'd gone back and forth about whether I wanted to do the podcast on this one. And then when he said he was from there, I was like, that's my sign. Tiki Bar Boat sounds like a blast. Tiki Bar Boat was a blast. It was so much fun. It's so funny you say my bun is perfect today. Look, this is Gulf hair. I have not washed my hair since I went swimming yesterday. So this is saltwater / bedhead hair. But so for whatever reason, anytime like I spend the least amount of time getting ready, that's when I get the most compliments from y'all. Go figure. All right. Oh my gosh. Yes. The dolphins. Okay. Hold on. I got to show y'all this. I'm glad you said something about the dolphins. I forgot real quick before we get started, because Lord knows there's, sad stuff happening. Let me show you something fantastic before we get into sad stuff. Okay, these were the dolphins swimming in front of our boat yesterday. Like literally right at our boat, swimming along with us. How cool is that?
Oh my gosh.
And like that's just one of the videos. I mean, there were so many, and like pictures and stuff that we took of them just hanging out with us. Like they're literally just swimming with us, hanging out. How cool is that? We could have like reached out and petted them.
Oh my god.
I just think I can hear my loud. I don't have my headphones on, so I didn't realize that my loud voice was ringing out. And aren't they pretty? How beautiful is that? I love me some dolphins. Dolphins, sea turtles, pandas, sloths. They're all some of my favorites. Like if ever I wanted Lucy to have like a brother and sister, or brothers and sisters, I would just get one of each of those. I think she needs like a little, baby panda and a sea turtle. If y'all could see my condo, like I have sea turtles. I have like a little collection of sea turtles and stuff. And I like to collect like the little ones, and they're so cute because I think they're just so pretty and so special. And I'm obsessed with them. I love them. So dolphins, sea turtles, pandas. Now that my thing with pandas didn't even start until we had our field trip to the zoo that one day when we did our like choose your own adventure thing, and we were looking at some of the live cameras, and I saw that one panda fall down and like just tumble over in all of his chubby little glory, and I was like, this is my spirit animal, like just chubby and clumsy and all those things. I love it. So anywho, but that's something nice and happy. This is why when I did the cruise, when I was talking about swimming with the dolphins, that's why I was so obsessed with it, because I just wanted to. Oh, I just love them. And then the pandas, and I still have like my little. See, I got this as like a gift. So my little panda thing here, isn't that cute? So I'm just all my little animals. I just want a little zoo. Alrighty, let's see. Yes, I love the dolphins. They're so cute. Like just the like I need to start my own zoo. I need a panda and a dolphin. Well, I need a few dolphins. Um but see, I don't want them to be like it would have to be like I need to like win the lottery, which I don't play the lottery, so that makes it really hard to win, but I need to like win the lottery so I can like buy like like I don't know, like half the state of Florida. That gives them plenty of room, you know. I'm gonna be like the new Tiger King, except for without all the like weirdness and felonies. But I want, you know, pandas and dolphins and sloths, goats. Gotta have goats. And my aunt and uncle have goats back in Georgia, so I can just, you know, get some of theirs, you know, next spring. And then what else do we need? We definitely need sloths. Um, Monkeys are adorable. We could do monkeys. I'm going to need a bigger apartment. Yeah. I need a bigger apartment. Oh, hummingbirds. Hummingbirds are cool. Love them. I like me and when I lived in Ohio, me and my kid used to sit on the back porch all the time and watch birds. Um, Alpacas. Tell you what, I'm not going to have. I'm not going to have. What is it? An ostrich? What are them things? Are they ostriches? Let me tell you about ostriches. Ostriches are not your friend. They are mean little things. I went to there's like a little petting zoo type thing here in called Zoo World in Panama City Beach, and look at Lucy. Look at her. She is so very sleepy. We went on a long walk today. Um, they they are they are not friendly creatures at all. I had on like this like a cover up thing, and it has like the little not tassels, but like fringe type stuff hanging off of it. And I had like the food that you know we were gonna like feed them or whatever, and you know I'm trying to be nice, and so I reach out and I'm gonna feed it, and then like the fringe was hanging on my thing, and one of his like you know bad news cousins over there comes over and starts like trying to get my fringe, and then starts like pecking at me, and my kid who is useless in this moment is just taking pictures and laughing instead of actually trying to help me from this ostrich attack. And it was you know one of those moments that I realized, you know what, not all animals are funny. They're not all sweet, they're not all cute. Some of them are jerks, and that ostrich at Zoo World in Panama City Beach is a jerk. You heard it here first, and I don't feel bad for saying it. He was not nice. And I swear, after he attacked me, and I'm upset and like trying to back away, but then also feeling guilty because the one sweet ostrich was actually eating the food I was giving him. Then I'm trying to back away, and I swear all of the other little delinquent ostriches were over there laughing at me. Ostriches are buttheads, just so y'all know. I mean, I hate to stereotype all ostriches for the behavior of just a few that are, you know, acting like delinquents at Zoo World in Panama City Beach, but I'm just saying they're out there and they're not all nice. Geese will chase you. Canadian geese are just as mean as ostriches. Let me tell you, it's like that devil bird gene goes through some of them. They'll hiss at you. Canadian geese and possums will hiss at you. I'm just trying to help y'all so that you know what to do in case of an ostrich attack. Trouble says there's an ostrich farm about 2 miles from me. I've never been. You need to move. 2 miles is too close. Have you seen them run? 2 miles is too close. You need to move. We'll start a GoFundMe to get you up and out of there and get you to a safe place. I will say this: there is a giraffe named Tony at Zoo World, and the giraffe at Zoo World is sweet, but also I think he leans over the fence and laughs at people as they get attacked by the ostriches. So I don't know how sweet he really is, but he seems nice. Auntie Candy, no, I have not checked it yet. I was planning on going today because I didn't think we were going to be streaming, and then I haven't had a chance. So I'm going to go as soon as we finish today. I don't think that they're going to be starting the trial today. So as soon as I get word for sure that they're not going to, then we're going to cut off. I got a few things I need to get done today that I was in the process of doing before this happened. And so I plan on going today, so I will look. I'll be excited. Then we can show it tomorrow. Lucy loves her little gifts. There was just a giraffe born with no spots. It's the first ever. Oh my gosh, that's so cool. I think giraffes are so cool. Peacocks are beautiful, but really mean. There's a white peacock here at Zoo World in Panama City Beach. Hey, Dean Sparks. Yeah, we were just talking about this. I had my scanner on, but I had to turn it off because I kept getting distracted trying to listen for it. But we're trying to watch for updates without me being too obsessive about it, because y'all know how I can get. It makes me nervous. But I turned the scanner off, so as soon as y'all hear anything, let me know. Let's see. All right, so oh my gosh, yes, April. When April the giraffe was pregnant for like 27 business years. And I thought I was pregnant in the Georgia heat because I went into labor. This coming up weekend is my son's birthday. He'll be 20, and I went into labor on Labor Day. So I thought, there's nothing worse than being pregnant all summer in the Georgia heat. And I thought that was true until I saw that it was possible to be pregnant for 27 business years, or however long April the giraffe was pregnant. She was pregnant forever. I mean, I'm about to Google it. We just get off topic here. I can't see on that computer. How long was April in labor? So she was in labor for a couple hours, pregnant. 15 months. 15 months. She was pregnant for 15 months. Y'all give it up for April. That's a man. She was pregnant for 15 months. I thought 9 months was like the longest of my whole entire there's no possible way it could take 9 months to cook a youngin', because by the time I was like 7.5 months pregnant, I was so big. I was like, there's no way it takes another month and a half to cook this youngin'. Like, he needs to get somewhere. And 18 to 22 for elephants. Good Lord. Let me see something. Okay. Longest animal pregnancy. Okay, an African an African elephant, 22 2 months. Frilled shark, 3.5 years. Can that be right? Orca, 17 months. Blue whale, 10 to 12. Giraffe, 14 to 15. A walrus, 15 to 16. Indian rhinoceros, 15 to 16. Humpback whale, 11 months. Elephants have the longest pregnancies of any mammal at almost 2 years. Jeez. 2 years. 2 years. 2 years. 2 years of being pregnant. Can you imagine? 2 years. That's insane to me. I can't even, nope. One and done for me. Oh, y'all want to see the shortest? Let me see. Shortest animal pregnancy. Let's see. Opossum. The Virginia opossum has the shortest 12 days after mating. And it gives birth to 16 to 20 babies. It only takes her 12 days to cook up 20 babies. How is that even possible? I had a cat named Possum once because she had a little pink nose. And she was like gray, but she had white right here. So it made it look like she was like, had like a little possum nose. So her name was Possum. And now every time I see a possum, I think about a little possum cat. All right. Domestic white mouse. Look how cute he is. 19 to 21 days. Hamster, 18 to 21 days. This is a true crime channel. And what are we doing right now? Guess who didn't take their medicine? But yet here we are. It's fine. Everything's fine. A meadow mouse for 20 to 21 days. Rats, 22 days. Gerbils, 22 to 26. A wombat. That's a cute little wombat. Muskrat. Domestic rabbit. We had rabbits growing up. Chipmunk. Look at little Alvin. Aren't they just precious? Well, I'll say this. If reincarnation turns out to be a thing, I just pray to the good Lord above I don't come back as a dang elephant for 22 months. If I come back as an elephant, I'm going to be a celibate elephant. I'm going to be a celibate elephant. Best to believe. I ain't spending 22 months of my elephant life. It's crazy. Crazy. All right. So we're off topic. Surprise, surprise. Can we look up the giraffe? Yeah, why not? We're making use of our time here. Giraffe with no spots. Look at that. Oh, bless it. A spotless giraffe. How cute is that? Celephant. A celibate elephant. I'll be a celephant. Yes. That's what I'm going to be. Or it could be a male elephant. I guess that would be more likely. Hello.
What? Did we just become best friends? Yep.
I forgot I don't have my headphones on. Did that work? Did y'all hear that?
What? Did we just become best friends? Yep.
Happy 2-month anniversary. Happy 2-month anniversary. We're so glad you're here. So glad you're here. Diane McMillan says, what's happening here today? Well, the jury has been selected. So we are just waiting for the feed. They're going to start. I guess we should quit with our zoo trip, and I'll tell y'all a little bit about what this is. They've got the jury selected. So let me tell y'all kind of what's going on with this trial. So I was able to pull up all of this stuff, but let me get into this. I have some of the documents and stuff, but we'll just go into this. All right. So 13-year-old Walterboro girl died under awful circumstances. Okay, so her name is Cristina, and she was left in a hot car in August by her mother and her mother's boyfriend. They were charged with her murder. And I originally thought that they were being tried together, but it looks like they have split their cases. So I think that this is just the trial for the mom, from what I understand. Now we're back in South Carolina. We are in South Carolina now, and this is Judge Newman. Y'all know we love us some Judge Newman. So this is going to be Judge Newman, bring the jury and all that. I love him. I'm excited to be back with him. It's a horrific trial, but it is, if anybody's going to keep a hold of that courtroom, it's going to be Judge Newman. All right. So according to Rita, she'd briefly gone inside the home of her boyfriend, Larry King, that is his name, to retrieve a pack of cigarettes. She told deputies that when she left her daughter, Cristina, inside of her 2012 Volkswagen Jetta. But when Rita came back outside, she claims her car doors were locked with Cristina and the keys trapped inside. By the time Rita said that she and King were able to retrieve a spare set of keys and get Cristina out of the car, it was too late. But, okay, first responders said that when they arrived, Cristina was out of the car but wasn't breathing. They said that she was beyond help. So she was in there for 5 hours. But here's the problem. Detectives got a search warrant and see security camera video from King's home, from the boyfriend's home. The recording told a far more sinister story. So the video reportedly shows the couple. They bring Cristina inside. Now, Cristina was born. She's in a wheelchair. She has special needs. So she was nonverbal, and she could not, she wasn't able to, she couldn't have just gotten out and walked herself. So she was 13. This is not like a baby, but she was not able to get out and go inside herself. So them leaving her in there, it's bad. The video reportedly shows the couple bring her outside of the house around 11:15 a.m., place her inside Rita's car, shut the door, and leave her there. The video shows that the pair was gone for an hour, after which they're shown briefly returning to apparently check on Cristina, then going right back inside the house. Oh, that makes my stomach hurt. They didn't come out again for another 3 hours. And when they did, they got in King's truck and drove away, staying gone for another hour. Temperatures outside reached the high 80s in western Colleton County that day. Inside a vehicle, temperatures easily could have exceeded 130 degrees in those conditions. She suffered severe developmental disabilities that left her unable to fend for herself. She was bound to a wheelchair, nonverbal, and utterly helpless without her loved ones taking care of her. That means despite her age, Cristina was essentially trapped in the vehicle for 5 hours, unsure of what was happening to her. Oh. 2 days after Cristina's death, Colleton County detectives charged Larry King and Rita, that's her mom, Rita, with her murder. Now, also, Rita is she was named Teacher of the Year in 2014 at the school that she's at, and she has another daughter who I believe, y'all, it literally makes my stomach hurt. She has another daughter who I believe the other daughter said that she believe that her mom, that like it was an accident, but video says it's not an accident. All right, so let's see. The pandemic had a direct impact on investigation. Lead detective on the case for Colleton County Sheriff's Office passed away in 2021 due to complications from coronavirus, contributing to further delays for prosecution. So basically, it got delayed. There's also it makes my stomach hurt. It makes me like physically sick. Okay. All right. So, Cristina was born with severe intellectual and physical disabilities that resulted in her being in a wheelchair and unable to communicate verbally. She was left in a parked Volkswagen Jetta owned by her mother. As a result, she died. All right. Prior to Cristina's death on August 5th of 2019, DSS had been notified numerous times regarding the inappropriate care provided to Cristina by her mother. On 5 separate occasions, my stomach still feels like sick. Stuff like this just gets me, y'all. Ooh. Okay. Get it together, Brandy. On 5 separate occasions, contact was made to DSS regarding concerns that individuals had regarding the care Cristina was receiving from her mother. The last contact DSS had with Cristina was March 18th, 2019, related to a severe burn on her face, neck, and chest. South Carolina DSS was alerted by the Colleton County School District after Cristina was sent to school without a bandage and the wound was draining. And then they contacted her mom, Rita, requesting that she seek treatment for Cristina's wound. Cristina was not provided medical care for her wound as requested by DSS on March 18th, 2019. So on March 19th, Cristina was once again returned to school by her mother without treatment. The school district described Cristina's wound as smelling and draining on her shirt. The school district raised additional concerns to DSS that Cristina was not being cared for properly at home by her mother. This was the 5th interaction South Carolina DSS had with Rita as it relates to the care of Kristen. It says Kristen, it should be Cristina. Yet took no further action. Oh, thank you so much, Candace Hoff. Thank you. Thank you. Thank you for sharing. I appreciate that. Thank you so much. Whew. Got to get it together. Sounds like UNC shooter is in custody. Let me turn my scanner back on.
Both drivers denied any medical symptoms and declined assessment by EMS units. Your discretion.
Candace Hoff gifted 5 memberships.
74, can you repeat your last traffic?
Hannah Fullwood, Judy K. McGee, Angie Burr,
Both drivers involved in the wreck deny any medical
Anna A.
issues at this time.
Mayla's mom. Okay. All right. They said she was not being cared for properly at home by her mother. 5th interaction, yet no further action. Yet they took no further action. Okay, so Rita's the mom, stated to DSS that she was frustrated with the school and would no longer send Cristina to the school when she was injured because they will report her to DSS. South Carolina DSS failed to intervene in any way. Um, so they're saying that defendants failed to exercise the slightest care and were negligent and grossly negligent against plaintiff in the following ways. The ways we just talked about pretty much, and failing to protect her. Like, it still makes my stomach hurt talking about stuff like this. It is, I can't even imagine. Brooke, member for 3 months.
What? Did we just become best friends? Yep.
Yes. Happy 3 months. We are glad to have you. Glad to have you here. Part of the fam. All right, so that's so that's against the DSS, the South Carolina Department of Social Services. Amy H51.
What? Did we just become best friends? Yep.
Happy anniversary to you as well. We are happy to have you. So glad you are here. Happy to have you here with us. All right. So let's see. We've had charge is murder. Motion, discovery, motion to suppress. I don't know what they filed to suppress, possibly the video. But see, I was able to pull this stuff up, but I wasn't able to pull up like the docket documents. So I'll have to look. But whatever it is, we'll hear it during trial. So apparently now we are just waiting for them to start because they have selected the jury. I don't think they expect this to be a very long one. Which is good. I don't think I could handle this one if it were going to be really long. So we are hoping to see justice for Cristina quick and swiftly. And knowing Judge Newman, that's what we'll get. I love him. Queen Oliver Than, member for 4 months.
What? Did we just become best friends? Yep.
Happy 4-month anniversary. We're glad to have you here. So glad that you are with us. All right, let me pull up. I don't see. It still shows on UNC. Oh, sorry. I didn't realize we're in the way. It still shows on UNC police. Oh, we're live. To stay sheltered in place.
Both of those are criminal offenses. Both of those took place with both time and date, all of that is the same as the murder and the unlawful conduct for the unlawful harm for a child. The name of the victim is the same. The name of the defendants are the same.
The indictment under that doesn't have anything.
Let's see if that helps
The
with the.
indictment I'm looking at doesn't have anything list on page 9. It doesn't put us on notice as to did they conspire to murder the child, conspire to hurt the child, did they conspire to cover up whatever might have happened, did they conspire to commit some other unlawful act. Again, I can't go into an opening statement and explain to the jury what the facts are going to show as relates to this indictment. I don't know what this indictment says they did.
We're going to have the jury come out and let them go. Then we can continue talking. I'm not giving them any charge of what to go. You know, we haven't, whether this one is quashed or not, well, it has no impact on whether the jury stays or leaves. If you bring the jury out.
Bring the jury. I've got. Happy 1 month anniversary, Angie Burr. Oh, it feels good to see Judge Newman. I don't know. That guy was not talking into the microphone. Shame on him. So I don't know if that's why it was so bad. I turned it up just a little bit to see if that helps. But when I do the enhancer thing, then this pink thing has to stay up here. My little.
What time tomorrow do they need to come in? Opinions.
So I'll be here when you tell me to, but if it's whatever it is to be there. Are you staying here or are you traveling?
I'm staying here.
Traveling, but I can make it on the way there. 9:30. I'm traveling a little bit discretion.
Yeah, but
No, we want them. I'm talking about the jury panel. We're about through with your motions.
I don't have another free trial. I do.
Well, my question is, what time should the jury come back tomorrow? In your
We'll be
opinion.
ready to go when they get there tomorrow.
Yeah. So do they have whatever elevator fixed or do they have to come to the courtroom?
I love Judge
So they'll
Newman.
come back. They haven't come to the courtroom. So maybe be there early as we can do. Well, all right, welcome back. We still need to deal with some matters before presenting anything to you, so we're going to let you all go for the day as opposed to holding you back there. We need you to return at 9:30 tomorrow morning. And again, once again, please do not discuss the case. Do not view any news media concerning the case. Do not go on Facebook or Twitter or any other social media site to try to find out something about the case. You're not supposed to be exposed to any information about the case other than that which you receive here in the courtroom. And it's very important that you follow those instructions. And so we'll see you back in the morning. I know that inquiring minds would love to know for you to come and tell them about that case you've been picked on. You're not to discuss the case with anyone. Not let anyone talk you into saying anything about this case. So we'll see you all in the morning at what time? 9:30. All right. Have a good evening.
So they're sending the jury home. They've got a few things that they have to iron out between them now. And then court will start at 9:30 Eastern tomorrow.
We're going to take about 5 minutes and then plow into the next matter.
I think we've got to finish Mr. King's conspiracy.
Tell us it later. Okay, good.
Take your eggs and go home, jurors.
Indictments.
We'll see what they say about what they're about to go over and if we get to watch it or not. And if we do, we'll watch. And if not, then we will start tomorrow morning, bright and early. Dean Sparks, active shooter in custody in Chapel Hill. Whew. I bet he does. I bet he has people everywhere that just tell him, you know, they think he's the bee's knees. He's awesome. I think, too, because, you know, we spent so much time with Judge Newman, like so many weeks with Judge Newman every single day, that having another trial with him is just like, it's like going to work for an old boss you used to love. Yeah, because I love when he shows up on court cam. I love him. People still go to that courthouse for tours after the Murdaugh case. Isn't that crazy? You know, the new case that I'm looking into, the one I'm doing the podcast on, I've been comparing it to a like kind of like the Boston Murdaughs. That's what I've been calling them, because it's like, imagine having a family that's so influential and, you know, has so much power in an area and their tentacles spread everywhere. That's how it is with this new case I'm looking into. It, and I keep calling them the Boston Murdaughs because that's what they remind me of. All right, so while they're doing this, let's pull up. UNC Chapel Hill says all clear, resume normal activities. girl. Hey. Um, look at this. This says, just got this video from my friend who is hiding right now during the shooting at UNC Chapel Hill. He's watching the cops search for the shooter. How scary.
I like the argument.
If it's live, as Aaron Thomas is standing probably 100 feet away.
As we were just shook.
So this is him being loaded into. What is wrong with people? I'm glad that they got him.
That's and again, legislation is extra. You're not allowed to.
Oh, you are.
I don't ever sell it. I do this thing.
You know, I didn't should have on the eve of CSC of the mind came in.
It's crazy.
Every 6 months is a lot.
It is nice. It's a welcome gift.
All right.
All rise. I was trying to pull up some more information on it, but
Criminal conspiracy.
Your Honor, I guess just for the record, Defendant Pangalangan will join in co-counsel's motion, or co-defendant's.
You don't know what he's accused of. Okay, what says the state?
We go back to Say versus Gentry when it comes to the adequacy of the indictment, specifically in this case. It specifically talks about, number one, the court knowing what sentence to hand down. That's not a question. The court knows what sentence to hand down. Second, whether the defendant calls it, whether he knows to plead either an acquittal or a conviction, whether he needs to plead guilty or go to trial. And then it really talks about, and something that was interesting that I didn't notice just a few minutes ago, in determining whether an indictment meets the sufficiency standard, and again, requiring it as a notice for them for crimes that they're charging them with, the court must look at the indictment with a practical eye, viewing all the surrounding circumstances. And they mentioned a case called State v. Adams, 277 South Carolina, 15. So I looked at State v. Adams at the break that we just had. State v. Adams, they charged him with burglary. And in burglary, as Your Honor knows, is breaking and entering into a dwelling with the intent to commit a crime therein. The argument by the defendant was, well, you didn't say what crime I was going to commit when I broke into the house. Therefore, the indictment's insufficient. The court said no. That's not. The judge can look at all the circumstances. And in this case, Your Honor, you've got 3 indictments. These defendants were charged with 3 indictments at the exact same time. They know what they're here for. They know that the conspiracy is simply the 2 defendants working together. If it is insufficient from an evidentiary standpoint, that would be something at the verdict stage. But for this, the sufficiency of the indictment, the question is, do they know what they're defending? And I think it's a little bit incredulous to say that they don't have a clue where the conspiracy comes from.
Is this a, let's say now, conspiracy? You have what, a common law conspiracy, and what's the other?
I apologize, I'm sorry.
Conspiracy.
It's a statutory.
Statutory or common law. And this is statutory conspiracy.
Statutory. I think I put that. I don't have the indictment. I handed the indictment back up to you.
It says against the peace and dignity of this into the statute. Yeah, mentions the statutes.
Again, a burglary case where he says, we broke into the house at 1517 Maple Street with an intent to commit a crime there. Yeah, that puts you on notice. You know what it is that you can defend. We broke into the house. We didn't break into the house. We were invited to the house. I have an alibi. I wasn't at the house. But for this to say, they conspired to commit some unlawful purpose, unspecified, and bring 2 separate charges. And so they could be a conspiracy to commit murder. It could be a conspiracy to hurt this child, or it could be a conspiracy to cover up whatever happened afterwards. And if we go into an opening statement, again, those are wildly distinct, or at least very distinct factual scenarios.
Well, you want them to say that they conspired to commit a murder or conspired to cause great commit the statute involving assault, great bodily injury on a child.
Or they conspired to commit misprision of a felony, or they conspired to cover something. I don't want them to do that. What I want you to do is to quash the indictment.
Oh, I know. But if they're required to do what you're seemingly suggesting, that elevate the crime to maybe accessory before the fact or accessory after the fact. Are you asked? Is that what you're sort of seeking?
No, and they haven't.
Well, if they did, if they did what you're saying they should have done, does that make them? Would that make them an accessory?
I don't think they could. Not if they're. I don't think they could be an accessory to a crime they're accused of having committed. I think they could either be a principal or an accessory. So if they're accused of having committed the murder, I don't think that they could be an accessory to that murder also. I think that what they should do if they're going to say you conspired to.
You said you can't be charged with the murder and accessory before the fact.
I don't know, sir. I don't think you can. I think you are either a principal or an accessory, and I also think the accessory before the fact or the principal distinguishes sort of academic.
Well, maybe this discussion is academic, because where does the law require that you specify anything more than this indictment does?
I think if this is,
it doesn't say. I mean, do you have any authority that the state must specify that they're in conspiracy to cause great bodily harm, conspiracy to commit a murder, such as your burglary or the burglary that was referenced, conspiracy to commit a burglary? Do you have authority where the indictment must be more specific than this?
Your Honor, I do not have authority at my hand which says that. My understanding is the principle is that this
All right.
indictment is to
Well,
serve.
if it exists, Mr. Phillips would have it, I'll tell you that.
My understanding, well, I don't know, he didn't make this motion, so maybe he didn't look at it.
He joined in, though.
And he may be finding. However, if it's a notice document, again, I don't even argue. I don't know what I don't know what to defend.
Okay.
Thank you, John.
So this is about the
Yes, sir. Mr. Phillips, anything further?
boyfriend.
Not on, well argued.
Anything further on this issue?
No, sir.
I think the indictment is sufficient based on the statute. And if the state fails to connect the dots and prove a criminal conspiracy in violation of the law, then the court will direct a verdict.
The only thing I will just say that is we have the presentation of reckless disregard for human life, but conspiracy is the intentional act. I think we do have that contradiction. I'm going to keep bringing it up.
Well, just reflect on the death penalty case they had in Clarendon County where boys were accused of going in and robbing a convenience store and killing the owner, facing the death penalty. And the only thing that they came out being convicted of was criminal conspiracy. So it's standalone. And the solicitor there was happy at least he charged with criminal conspiracy.
We're not really concerned with saving the case.
All right. What's next?
Yes, Your Honor. The defendant, Pangalangan, does have a motion for suppression of untimely and prejudicial disclosure of evidence. A couple of different things. There's multiple pieces of evidence that I would argue is disclosed late, but I'm going to focus on one first, specifically on August 18th, the state conducted tests on a vehicle in which the decedent was found. That was 1,474 days after the defendant's arrest on August 5th, 2019. Failed to disclose those video recordings or tell us about it, I believe, in the status conference that we had until Wednesday, August 23rd, 5 days later, with no accompanying information, just 2 short videos of the vehicle and tests being done, and then subsequently disclosed Volkswagen certifications for Jason Vigalotti and Michael Malinsky on this Friday, August 25th, with no additional explanation or documentation, no reports. It appears, based on what is presented in the witness list, that the state is going to either present testimony or presentation of these videos for Michael Malinsky and Jason Vigalotti in this case. Now, again, I don't want to muddy the water, so I'm going to stay with just this one first. In looking at kind of the timeline here, we go all the way back to where I first came in the case on November 9th of 2022. I mailed a copy of the motion for discovery, Rule 5.
It starts tomorrow.
Rule 5 to the solicitor's office. On November 16th of 2022, Solicitor Duffy Stone sent a letter to all the defense counsels indicating his intent of calling this case for trial in August. And then on May 24th of 2023, our Supreme Court issued a general sessions docket management order, became effective on July 3rd of 2023, requiring the timely disclosure of discovery, specifically indicating that case should not be put on a trial docket until all the discovery is complete and been provided to defense counsel. Specifically, it says the solicitor shall not list any case in which the state, the
The solicitor and law enforcement has not complied with Rule 5 and Brady at the time of the proposed trial docket is transmitted to the chief and the clerk of court and used in order in terms of discovery. It's any material subject to discovery under Rule 5. And then specifically on June 21st, 2023, we received an email from the clerk's office scheduling this case for trial during this court term of August 28th. Then on August 7th, I emailed a supplemental motion of discovery to them, requesting different things, specifically would have been additional video recordings. Then on August 18th, we had our status conference, and these tests were conducted on the vehicle. And then on August 23rd, again, that's when the disclosure of the videos were provided in an email. At that point, again, no accompanying information. It was just 2 videos. And then 2 days later, last Friday, we had certifications for Jason Vigalotti and Michael Malinsky, just Volkswagen certifications, no reports of what they did. I did a follow-up email on August 26th, the next day, to Solicitor Thornton asking or inquiring when the videos were done, who was present when the videos were recorded, if background checks on these potential witnesses were done, the subject matter on which these potential expert witnesses are expected to testify, and the substance of their testimony. In response, Solicitor Thornton provided the following. Quote, the videos were done last Friday. Present were Malinsky, Vigalotti, Dylan Hightower, and Jason Chapman. They are the same folks who may be heard and seen in the videos. Do not have wraps on them, but we'll get those to you Monday along with the others. Sorry, Madam Court Reporter. Those are the same folks who may be heard or seen in the videos. Do not have wraps on them, but we'll get those to you Monday along with the others. They may testify as to the vehicle, its operation, and its interaction with the key fob. Also, whether the key fob can be locked in the car. And so specifically, again, I'm not going to muddy the waters with the others. Take this one piece at a time. When we're looking at how this unfolded, it's been 1,474 days since the defendant's arrest, 280 days since Solicitor Stone's letter calling the case for saying he was going to call the case for trial in August, 91 days since our Supreme Court issued the General Sessions docket management order, 63 days after we sent an email or received an email from the clerk of court's office scheduling this case for trial, 16 days since we sent a supplemental motion discovery, 5 days after the tests were conducted, and then 5 days before trial for just the videos. I got to be specific here. My motion is to suppress the testimony and videos on this specific, and again, I'm going to go into the others in a second, but specifically suppress this evidence, not only based on Rule 5, but also given the General Sessions docket management order and Early v. State, or our South Carolina Supreme Court, that's 418 SC 255, noted that the purpose of Rule 5 is for the defendant to have a meaningful opportunity to prepare a defense based on evidence that may be introduced at trial. Given this situation, the prejudice is now that I don't have the time to retain my own expert, to review the car, inspect the car, review the videos, and then, of course, potentially have rebuttal expert testimony in trial because of the 11th hour disclosure of this evidence. So to me, our specific arguments that the prejudice is on its face, it's apparent through the late nature. It's 4 years later, and we're having potential expert witnesses. And the way it's done on Wednesday and then Friday after it was done the previous week leaves us in a position where I don't have the ability to retain my own independent expert, conduct tests and inspections, potentially have rebuttal testimony. So I'll save the rest, but I think specifically, given under what's here, and I hate to pound the chest a bit, but I think there has to be sending a message that the whole purpose of timely disclosure of evidence means something. And having this is a tactic that puts defense counsel at a disadvantage and impairs the defendant's right to a fair trial or right to present a meaningful opportunity, or I'm having a meaningful opportunity to present a full and complete defense. And that certainly violates the 5th, 6th, 14th Amendments to the United States Constitution, Article 1, Sections 3 and 10, 3 and 14 of the South Carolina Constitution. It's just fundamentally unfair to have discovery provided in this manner, specifically when there's no reports given the just over-dilatory amount of time provided. And I'll take it piece by piece, but that's the first step.
Piece by piece on the same issue?
Well, so we have multiple different issues related to discovery, but for the JED, I figured it's easier for the record, easier for your honor if we take it by evidence.
Anything you have to say on that, Mr. Boyd?
Your Honor, I would like to join in the motion in all candor, Mr. Gash and I later to the things than Mr. Phillips. I don't know.
All right. Response by the state.
Thank you, Your Honor. May it please the court.
Yes, sir.
You know, I think this may fall under the category of no good deed goes unpunished when I provided something I'm not required to provide. Obviously, under Rule 5, I don't have to tell Mr. Phillips who my witnesses are or what the substance of their testimony is going to be, but I did try to do that when he asked. I would also note for the court, and it's actually in Mr. Phillips' motion, on page 6 of 11, there's this thing we call continuing duty to disclose. So these videos were created at a test determining the locking and the interaction of the vehicle with the key fobs on Friday, and it was Friday, I think it's the 18th. It was, and it may have been the same day as our status conference, but it was late in the afternoon. Mr. Hightower was present with them. The videos in question, I think the two videos together are a total of a minute or less than a minute. And they were done. It was created on Friday, that Friday, the 18th. I believe they were uploaded into our system by Monday, and I sent them to him sent the two things on Wednesday. He emailed me back and asked, the email he basically read you, Judge, who are these people and what's the substance of their testimony, which I gave him the basic tenet of. But, in the case management order, I've heard he's the second or third defense lawyer that I've heard get up and say that it says discovery's got to be complete. What it says is that we have to be in compliance with Brady and Rule 5, and stuff like this is why. This information didn't exist until that day, and I turned it over. It was done on Friday. I turned it over the following Wednesday.
Is this docket management order now being elevated to the status of a statutory rule?
Yes, sir. I'm getting beaten up with it just about every time. The first thing they say is, well, Judge, they gave me something. They gave me a piece of paper after the case was put on the trial docket, and that's in violation of the docket management order, and it isn't. What it says is we have to be in compliance with Rule 5 and Brady. And I would also point out
it also says judges are to manage the discovery, and judges are to do this, and judges are to do that.
Yes, sir. And I would also,
how it's. Is that really a misnomer?
I'm sorry.
Is that a misnomer? Docket management order? Is that the?
I think it's an attempt to help everybody manage the docket properly, Judge. Beyond that, those decisions are made above my pay grade. But I can tell you what it says, and what it says is that we're supposed to be in compliance with Rule 5 and Brady. The other thing I would point out is
it also says judges are to do these first appearances and second appearances and coordinate this and schedule that, and now it's being cited in motions. A motion to suppress based on violation of a docket management order.
I have to jump in, Your Honor.
No, you don't. No, you don't. You don't have the privilege of jumping in. Rules are adopted in various ways, generally through the legislature, or if the Supreme Court's going to amend the rule, then there's a period of objection now, or a period through which it becomes law if unless, whatever procedure takes place. But this is new to me, that an order trying to manage the docket is being elevated in a murder trial as a basis for a motion to suppress. Now you can jump in now.
Thank you, Your Honor. That is,
I love
the
him.
General Sessions docket management order is at the bottom of the pile of the things that I'm relying on. We have.
Well, I realize that, but you're including it in your argument.
Sure.
So, I mean, you've got enough to go on
Yes, sir.
without throwing that in there.
Well, I think ultimately the Chief Justice would agree for the Supreme Court to issue this, it must have some basis in that. But also due process, fundamental fairness, obviously our right to confrontation of witnesses, her right to have effective assistance of counsel.
I think it muddies the water when you cite it as a basis for, one of the bases of a motion to suppress. And that's my position on it regarding this docket management order. It's obviously important, but it includes a lot of things that are not mandated by the discovery rules.
Yes, Your Honor. And I guess just to be clear, my request is also made on the defendant's right to a fair trial, his right to confront witnesses, confrontation of witnesses, compulsory process, meaningful opportunity to present a full and complete defense, effective assistance.
Well, we heard you the first time on all those other ones.
And Rule 5.
Okay, I understand your position all around, but
It's just, it puts, from a defense attorney standpoint, I'm now in a position I don't have time to do what I need.
I understand. You said that the first time.
No.
Go right ahead. Well,
Your Honor, with one, I apologize. May I add one thing?
yes, sir.
I was in the process of saying this and I stopped, and I apologize for interrupting the court. I would also point out, this is about functionality with the fobs and how fobs interact with the vehicle. The vehicle's been impounded, and defense counsel could have gone and seen it or gone and looked at it anytime he got ready. We haven't prevented him from doing so, just like we did.
Yeah, well, the point is a valid point. Offering an expert witness and an expert witness's report 3 days before trial or 5 days. Well, there's no report. So what are they going to? What's the basis? What are they going to testify to?
Your Honor, they will testify as to the fact that as to how the remotes, the key fobs, operate when the vehicle is running versus when it is not running. It's a demonstrative. You can look at the videos and see what they're doing. It's not really expert testimony in the sense like a DNA analyst or something. They're basically, and that's why it was video.
That's going to be my question. What's expert about that?
It isn't. It doesn't require unexpert opinion. There isn't going to be opinion testimony. It's just it would be factual statements.
Hi, Golden
In
Mayor.
response, they provided 2 days later, Friday, certifications from Volkswagen. Whether they end up pushing qualified, they're going to have these individuals up there in capacity for somebody that has at least some type of training and experience that the jury does not have, whether they try to qualify or not.
Stephanie, it's in the description of the video if you want to read it real
I'm
quick.
going to defer ruling on that, but I tend to agree with the defense on to the extent of offering an expert a week or 3 or 4 days before trial. But I'll defer ruling because I haven't heard enough testimony or anything about the case to get a sense of it all. I'm sure the case is not going to turn on what they did last week.
Well,
I would hope not.
our specific thing would be that the state is going to rely heavily on
Yes.
it. And with
How do you know that?
Well, again, I would be able to hire my own potential expert to do their own inspection, conduct an independent, potentially have a rebuttal if something.
Well, you've got time to do that if you want to do it. I said I'm going to defer ruling on the motion.
But I'm in trial now.
Well, if you want to get someone from Volkswagen to go out there, if you want to, I don't know. I'm deferring ruling on it, but you're continuing to argue it, basically.
I understand.
All
I'm
right.
just making my point clear. Your Honor.
What's the next issue?
Yes, so the additional issue, there is a CV that was provided very recently, I think within the last, correct me if I'm wrong, in the last week or so, David Egerton, and there's no reference in discovery of who this individual is. So I asked today, the basis of the testimony, and I think this will parlay into another motion that I have, that this individual is going to testify as an expert witness as to related alleged drug use from the defendants. And so I think we got a couple of different issues related to that. One, again, with understand his position is that he doesn't have to give us any heads up as far as his witnesses, but now that we have that, we certainly can wait to have that resolved because I do have a motion related to that, not only the 404B, but also additional motions related to that. So
I don't make preliminary rulings on these evidentiary issues prior to the trial.
So the basis we'll just address it when they call the witness.
Okay.
Based on the solicitor's statement earlier, as far as their intent is only to present the one statement from the scene, the other argument that I would have related to discovery is no longer necessary. I understand your ruling is certainly in abeyance at this point, and so we'll move to the next motion.
Okay. I only have one thing in abeyance, right, or two?
Specifically, I believe whether you're going to keep out testimony and evidence. Essentially, my motion to suppress the videos.
Key fob type testimony.
That's correct.
Okay.
Now, one matter may be cleared up from the solicitor. Again, they're the lead investigator on this case, Sergeant Macdarella, I hope I pronounced that correct, unfortunately passed away, it looks like on January 16th of 2021, and he handled a great deal of evidence. And I think, Your Honor, what you just said, that you're not going to do any pretrial evidentiary where we'll have to just address it as things arrive during the trial, but we have significant issues of potential hearsay, not only investigative hearsay pursuant to State of the King, but also just the hearsay level of the documents that he dealt with, because we have a confrontation clause problem as well, and then foundational issues and potentially authentication issues. So a lot of, unfortunately, happens when you have one individual who worked on evidence and has essentially a motion for suppression of evidence due to unavailable witness. However, based on Your Honor's statement that you're not going to provide any pretrial rulings on evidentiary, I don't want to go too far in, Your Honor, say that you're not ready to address that.
Well, I'd still love to know what's coming down the pipe. You said
And unfortunately, the problem is
suppression based on
the
unavailability of a witness.
Yes, Your Honor. And the problem that I'll have at this point is I don't obviously have privy to what evidence the state is going to seek to admit. So that is a conceptual problem of mine that we'll just have to address at the appropriate time. I wanted to make sure Your Honor is aware of that issue.
Okay. Any comments the state wants to make about that?
I don't understand it, Your Honor. I apologize, but I suppress what? I can't respond. He moves to suppress what exactly?
Well, I guess the first, if the state's willing to identify what's pieces of evidence that only Sergeant Macdarella handled that they intend to seek to present, then we can certainly address it piece by piece, or we can wait for the trial.
See, that's having a trial before the trial.
Well, I'm just trying to, it's the judicial economy, Your Honor. If we handle it now, then we don't have to stop.
Yeah, well, a lot of things that are labeled as judicial economy are really judicial delays. but it's all a matter of perspective. What's the next one?
Yes, Your Honor. The next is kind of a joint motion for the state to disclose 404B Lyle evidence, and of course, defendant's objection to the introduction of inadmissible propensity evidence. And so, with that motion to disclose what potential 404B evidence, that kind of then is bolstered by our objection to it.
What type of propensity evidence are we dealing with here?
It depends what that's why I have the motion to disclose the 404B, because I can't unring the bell if it comes out in trial and I'll have to move for a mistrial.
Well, that's when you make an objection, before the bell is rung.
Unfortunately, sometimes that's impossible. And so I'm trying to deal with that now so we don't have a mistrial issue.
Okay. Response by the state.
Yeah, we're not going to offer any propensity evidence. I don't think that's proper. I think any evidence that we would offer, again, the defense should have time to object. I'll tell you that the only thing that falls under res gestae as well as Rule 404B that would even be arguable are two witnesses. One is Brittany Honeycutt, and the other is Lindsay Lewis. Both of them have given written statements. I would like to give you a copy of those as well as the defense.
Lindsay Lewis.
Copies of statements. And those statements, one of the witnesses was actually with Rita Pangalangan for the Friday, Saturday, and Sunday. Excuse me, I take that back. Apologize. This happened on a Monday. The child was killed on a Monday. Rita Pangalangan left her child with this babysitter Friday, Saturday, and Sunday. And she describes basically Rita Pangalangan leaving the child with her and taking off, and she doesn't see her for the full weekend, didn't know she was leaving. That leads literally into that Monday. So this is literally part of the case itself under res gestae. The other witness is somebody who lived with Rita Pangalangan through the going up until, I believe, August the 1st. This happened again on August the 5th. In her statement, she said that, among other things, and again, I'll give you the full statement so you can view it. But among other things, she said that Rita Pangalangan told her, I need you to take the child, and I need you to take her with you. And she said, I can't do that. If the witness says I can't do that, I'm going to work. And she said, just take the child with you to work and put her in the car. That's what I always do. That, to me, Your Honor, again, this is on August. This is the time frame that she's actually leaving with Rita Pangalangan. It goes directly to the reckless disregard for the safety of the child being something that Rita apparently does pretty consistently, that she used to put the child in the back of the car. Again, those statements are all written. The defense has full statements of these things. They are about 2 pages apiece.
Happy 3 months.
In fact, Ms. Lewis's statement is two pages of order. Ms. Honeycutt's statement is 4 pages total, and the defense has that.
Yes, sir.
Thank you, Your Honor. Any evidence of that nature that's not resulting from a conviction must be explained or at least proved by clear and convincing evidence to be admissible. And pursuant to State versus Gore, when a prior bad act are similar to the one where a person's being tried, the danger of unfair prejudice is enhanced. So not only under the 404B, if an exception applies, we argue that it doesn't, but if an exception applies, you still have the 403 analysis that the probative value of the evidence is substantially outweighed by its prejudicial effect. And here it's not as a result of a conviction, and it's similar, so the danger of unfair prejudice is enhanced under the case law. We would argue that this is the exact, again, under propensity evidence is where there's smoke, there's fire. This is the exact reason why this should not be presented.
I've got the press conference pulled up too. for North Carolina. So as soon as they start on that, I'll pause this and we'll listen to it.
All right. You want me to review the, I mean, you can give me a copy of them
Yes,
to
sir. I'll
look
give you
at?
the statements as well.
Yeah,
I'll also
okay.
hand you State versus Martucci, which kind of outlines the use of both 404B and race gesta. It's actually a very good overview of the entire analysis, and in particular in child abuse cases. So I'll hand you that, and I'll give a copy of that to the defense as well, and I will give you these statements.
Yeah, it's just my offhand reaction to what I'm hearing without, looking at cases and all that, is that the context of it all, if the state is to prove a case involving the death of a child, and you have, I guess the defense is that it was an accident, it was inadvertent, it was, a loving mother who would never do anything to hurt her child or whatever. I don't know that of course, the state can't wait until the defense decides to offer that defense, because the defense may not offer anything. So the state has to be able to prove its theory, and I would think through circumstantial evidence, based on whatever circumstances exist surrounding the situation. I want to read these cases and
Yes, Your Honor.
deal with them, hopefully in the context of all of this. Every case is unique.
That's it. It's that one case. It's quite frankly such a good analysis, Your Honor, that it mentions other cases, but it summarizes it all very well. And I'll make, can I make copies of these? I have hole punches in them.
Sure.
I don't want to hand out before something.
These are some, well, these young ladies up here, they're very efficient with all of that.
Sorry. Thank you.
Well, and again, remember the course of 404B law has changed the way. I mean, specifically, we need to look at State versus Perry, 430 SC 24. But again, going back specifically here, and what I have for Your Honor, so you can follow when you have your ability to read their case, what was handed to Your Honor is the objection to 404B, again, what was marked as defense exhibit number 10. Under State versus Fletcher, our Supreme Court explained that clear and convincing evidence is the degree of proof which will produce in the mind the trier of facts affirmed as the allegations are sought established. That's when a prior bad act does not result from a conviction. It must be proved by clear and convincing evidence. If you have someone come in and say, well, I was told this a few days before, and it's not a result of clear and convincing evidence, and you take based off of the case law that it must be proven by that level of threshold of an evidentiary standard, and then you put that in context of State versus Gore, that when a prior bad act is similar to one for which the defendant's being tried, the danger of unfair prejudice is enhanced.
We know that.
And so our position would be, even if it satisfies the 404B exception in Your Honor's mind, that it would still have to survive the 403. And our argument would be that it survives neither, but certainly not the 403, given the context of what's provided, that its prejudicial effect is highly outweighed, substantially outweighed by any prejudice value that be presented.
That leaving a child with a babysitter would tend to think that the person is guilty of murder.
That's going to be that's exactly the argument he said they're going to make.
Okay.
I mean, that's exactly the argument from which they're going to say.
I mean, your case analysis, you're saying about prior bad acts, asking someone to be a babysitter, is that a bad act? Or to tend to my child, or have to wait in the car while you go to work, or whatever the facts are.
That's just not the way the state's going to present it.
No.
I wish it was that.
Well, we'll evaluate all this, but for me to judge, rule on this before the trial, That's another reason I don't rule in advance on
Understood.
critical issues.
Understood, Your Honor. The next motion really deals with, I think Solicitor Stone said he's gonna mark or pre-mark the photographs. We would have 4 or 3 objections to photographs there.
Because anything that they're offering you do not object to.
I haven't seen what they're, I haven't, that's,
You don't know of anything that you do not object to.
that's the problem. Yeah.
Okay.
Sure, I will.
Well, what about the photographs? What's the story there?
I don't know if they had an opportunity to pre-mark anything yet. I know they were in the process of one.
You have gory photographs.
We are not, Judge, here's the only, we've actually, going through, I think the Supreme Court just actually handed down a decision, Nelson, State versus Nelson, last week, or week before last. It has not become permanent yet, but it talks about autopsy pictures. We actually went back, we were going to offer one autopsy pictures of the child's leg. We've taken that out now. We do offer scene photographs. We have the child that was actually taken out of the car at the scene and on the scene, and that's the only photographs we have. I'm glad to hand those up to you. But scene photographs, even if you look at, say, versus Collins, which is a case in which you have an actual animal mauling case in which the child autopsy pictures were taken and were admitted into evidence.
Judge Birch's case out of Chesterfield.
Yes, sir. And that, and even in all of those cases, they're all referencing pretty much autopsy pictures. The only photographs we're offering are scene photos. This is literally how the child would have looked at the car, the way the child was taken out of the car, and then the way the child was left after she was taken out of the car. Let me, there are 4 photographs. And I'm going to, at this point, Your Honor, if I could go ahead and mark those state's exhibits so that we will have reference to them.
Yes.
Like I did. I've got the sticker right there. Yes, sir.
Your Honor, could we look at those briefly before they're handed out?
I would like to show these first to the defense. I'll also hand Your Honor the State versus Colleton, which is what we will rely heavily on. This is a South Carolina Supreme Court case that outlines crime scene photos. In that situation, this is the pipe bomb case of a 15-year-old girl that was, I believe, raped and murdered, and then the 2 defendants put a pipe bomb in her mouth.
Jesus.
And exploded it. The crime scene photos were taken not immediately afterwards, as they are in this case, but 46 days later.
These are pre-trial motions. The trial starts tomorrow morning at 9:30 Eastern.
This is how the body was found by law enforcement. South Carolina Supreme Court said this was proper to allow those into evidence under the same analysis that we do of the other ones, because it shows how the defendant left, what the defendant did, how they left the victim, and that was the very first look that law enforcement had. In this case, the photographs that we're offering, and I'll hand these up to you. I think I've shown them now to the defense. This is of the very day, within moments after the child was taken out of the car. And this is State's Exhibit 1, 2, 3, and 4. I'll hand those up to you.
No, he sent the jury home for the rest of the day. They're going to be back tomorrow.
Can you make a photocopy of these for me? That's okay. That's fine. Are those the photographs you were referring to, Mr. Phillips?
Yes, sir. Now that we have identified photographs, specifically as stated by Solicitor Stone, under State versus Nelson, that did come out back on August 9th from our South Carolina Supreme Court. Specifically, our position is that we move for suppression of the evidence here based that the photos have little to no probative value as to any disputed fact or to an element of murder. And again, under our 403 objection, another case that was recently decided by our Supreme Court, State versus Jones, that was filed on March 29th, the courts quoted, "It is well settled,
Yeah, this is
well
motions.
established that photographs that are
Trial starts
calculated
tomorrow.
to arouse the sympathies and prejudice of the jury are excluded
Yes,
if they're
ma'am.
relevant and unnecessary with the issues at trial." And of course, the buzzword is inflame the passions and prejudice of the jury, specifically that the jury would make a decision based on an improper basis, not based on the evidence. Seeing the photos alone would invoke such a response that the jury would not base their decision, their verdict solely on the evidence, but based on the graphic nature of the photographs. That any probative value of those photographs are substantially
Do you
outweighed.
object to all the photographs?
Yes, Your Honor.
We-
With Mr. Kennedy, we joined that.
Yes. All right. So we'll address that issue as the evidence develops.
Thank you, Your Honor. And our specific issue is just that a pathologist will be able to testify, explain the injuries, that the state will have other means of evidence that they can present through testimony of the pathologist, through the people that were present at the scene, to explain what was there that's not necessary to actually have to show the photographs as far as what actual probative value would be presented by actually having to publish those to the jury.
All right, we'll address that issue in the course of the trial. Certainly, they can be marked for identifications prior to being admitted or not admitted. What else do we have?
Thank you, Your Honor. The defendant, Pangalangan, moves to prohibit any inadmissible hearsay testimony regarding references to any illegal activity that's not contained within the scope of the indictments, and that's under the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 14 of the South Carolina Constitution. We look at Rules 801 and 802, the South Carolina Rules of Evidence. Specifically, this hearsay evidence that implicates the defendant or infers the defendant's involvement in some type of illegal activity or illegal doing of, I believe, based on my discussion with Solicitor Thornton, they plan to call an expert to testify about drug use from either one or both of the defendants. And specifically, given that, our argument would be that they not be able to present that. I understand that they now have what was presented to us recently, a CV of a toxicologist, but wanted to raise that motion.
All right, this,
I'm not sure how that's hearsay, Your Honor. Both defendants had methamphetamine in their system from blood draws. One had 400 nanograms per milliliter. The other one had 480 milligrams per. I don't see how that's hearsay. It was actually blood taken from their body. It was taken to SLED. It was tested by a toxicologist at SLED. The child also had her blood taken as well and tested. That was a toxicologist by the name of Demi Garvin, who's also on our witness list. Her CV has been provided, although Rule 5 doesn't require that. So from the standpoint of, I don't plan on offering any hearsay that's objectionable throughout any part of this trial. But certainly blood draws aren't hearsay. I'm not sure how that's.
and the blood was drawn when in proximity to the.
Right after the event. They were actually, both of them were taken from the crime scene to the hospital, and were taken, had their blood drawn at the local hospital.
And Your Honor, I guess let me clarify. I've had some confusion there. Don't have any issue as far as toxicologists. They're correct. That's not. You're saying whether we had any law enforcement officers make references to drug use or the fact of the toxicology results, if any of the law enforcement officers were to discuss that. The other portion of that would also be an argument under Rule 403 that the probative value of providing that they had allegedly this substance in their system would be substantially outweighed by its prejudicial effect. And I understand that all evidence generally presented by the state is prejudicial. And our position is, in this case, how it relates to what they say recklessness. I understand that their argument would be that that goes to their theme or theory, but our position is that if the probative value presented there is substantially outweighed by its prejudicial effect, because there's no additional evidence that corroborates or supports that somehow that resulted in what occurred that day.
And I would join in that argument as well as object to the introduction of testimony or evidence as to any uncharged crime. And they're not charged. Search warrants were executed at the home, at both homes, as I understand, on the vehicle, et cetera. There were no drugs recovered. They're not charged with possession of any drugs. And I think again, as was stated by counsel, that the probative value is far outweighed by the prejudicial effect. And so I ask for a ruling on that at least before we attempt to unring that bell that you said we can't unring.
If someone is on I guess on a drug binge, and is accused of committing a crime, is there authority out there that addresses that question?
And not to jump in, but I would just say there's no evidence that they're on a drug binge. If somebody tested positive, they could have done it 3 days before. That stays in your system
That's
for several
hypothetically.
days.
If someone is on a drug binge, I'm sure, and as is the case in many, many murders, many, many crimes, is there authority that addresses that issue?
I'll certainly research it. Our position, again, to
Well, that would be the question. If the state is saying, well, they were more focused on using drugs and tending to the child, and so therefore the jury should know about that, then there should seemingly be some case authority one way or the other on the issue.
I think there would have to be some threshold evidence showing that they're on a drug binge, because somebody could test positive.
Well, I just use drug binge as an example. The same thing can apply if heavily under the influence. If they were tested around the same time and had all these drugs, and a toxicologist will testify as to the level of drugs in their system and all that. I'm just, as you all are musing over these legal issues that I'm going to be asked to rule on, I'm posing the question, is there authority that addresses that issue in general?
Your Honor, I don't have a case to cite, but as far as a probative value, my client is accused of having done is to be present when a child that he has no authority over. If he had tried to take this child, he'd have been arrested for kidnapping. It's not his child. He's not a guardian. He doesn't pay support. At most, he's present at the scene. And so
their mere presence does not make a person guilty. We know that.
Right.
But that's a separate issue.
Well, I understand that, Your Honor, but without some threshold, well, I can address it when it comes up.
I don't even know the facts. I mean, we're just having a conversation more than anything. And I'm raising a question as to, you all throw out the issues and I'm just asking questions.
Your Honor, it's close to knowing the facts, because this is going to be one case where I don't think the facts are going to be a huge issue. What occurred pretty much occurred, and it's on tape. And we can almost go to closing argument.
Yeah.
I saw that they were being tried together.
Since you don't have an answer to the question about whether or not there are any cases that address the issues of
Then it showed separate, but if they're both there,
evidence,
I'm trying to find
of
out.
intoxication by the defendant, is there anything out there that addresses that? You say you don't know anything about it. I'm now asking the solicitor.
Yes, Ryan, I just wanted, so I can, as I'm looking, if you could clarify, I just want to make sure exactly, you're saying a case that would allow the state to present toxicology in a case that doesn't deal with drugs?
Cases that deal with the issues in general. No case, each case is going to be unique in its own respect, but you have principles that govern the types of situations. Mr. Stone.
First of all, Your Honor, I know of no case that specifically says that if you're high on meth or if you're drunk or if you are high on crack cocaine or whatever, that you can't introduce that if they're committing a crime. I can't come up with a single case that says no. I think that there is so much prevalence of drug use and crime in our jurisprudence that we literally have cases that say, and I'm quoting here, voluntary intoxication or the use of drugs does not constitute a defense to a crime. So it's the exact opposite of what they're arguing. It's such a prevalent issue in what we deal with in the courtroom that the Supreme Court, in State versus Hartfield, 300 South Carolina 469, literally goes to the trouble to say, by the way, that's not a defense. They can voluntarily use drugs, and therefore you can use that as defense. I think that's an indication how prevalent this is throughout our entire jurisprudence. I know of no case that says that's not relevant testimony for a jury to know that you under the influence of whether it be meth, whether it be cocaine, whatever, from an illicit drug standpoint.
Well, the defense seems to be saying, maybe yes, maybe no, that acknowledging that the defendants were on meth to a significant degree, the jury should not know about it. And that's the quintessential question in the case. And the state says, well, the jury needs to know about it.
I think it goes, you're talking about a case in particular with the murder charge of implied malice. And what we're talking about is somebody that has a total disregard for the safety of the lives of others. And you're talking about that from the standpoint of somebody who puts a child in a car and leaves that child in the car for 5 hours and 41 minutes on August the 5th in rural South Carolina in direct sunlight. The child literally cooks to death inside the car. And I think it's inevitable that the jury would say, what were you thinking? Because I promise you, Your Honor, as we're playing that video, that question will come through just about everybody's mind that's watching that video. I know it's come through mine 100 times. What are you doing? What do you think? Why don't you get the child out? At one point, they actually find that they've locked the keys in the car. And instead of breaking the window, they leave and go get a spare key for an hour. So I think if you look at that situation, the fact that they are high on meth becomes extremely relevant because it answers, what are they thinking? They're not thinking. They're more focused on, they are high on meth, therefore they're putting that child's life at risk because of that. Then the question becomes, does that voluntary intoxication give them the defense? Which is why, by the way, I have that case, just to make sure that we weren't going to go down that road. It is a crucial part to this case. It is central. And I can't fathom that there is a case out there that says that would not be relevant.
No cases that would say it's not relevant. Any case that says it is relevant. And since you brought your whole team here, you can have 15 researchers on that question. Well, any other comment on that issue?
There's no connection between the two. If they put the child in the car and drove to get methamphetamine, if they robbed the methamphetamine dealer, if the child was positive for methamphetamine, but if someone has used methamphetamine, as counsel has argued, within the last 24 hours or 48 hours, the act of leaving the child in the car is no more culpable, it's no more reprehensible, and it's no less. I can assure you nobody's using voluntary intoxication as a defense. So I can allay the solicitor's concerns on that. Am I correct? You're correct. We haven't discussed that, but I'm pretty sure that's not going to be a defense at all. There's just no nexus between the two.
Do you agree that homicide by child abuse cases are different than regular cases, or no?
Yes. In a jury's eyes, I think that they are. I think anything.
I mean, evidentiary speaking, I'm trying to prove neglect.
Well, this is not a homicide by child abuse case.
Well,
this is a different statute.
It may be a different statute, but it's still, sort of the same theme, isn't it?
No, Your Honor, because the elements of proof that are within the homicide by child abuse statute are different than what's presented in the murder statute.
Okay.
So, unfortunately, that's...
Well, the case that you handed up, is that a homicide by child abuse?
It is, and it describes all of those issues, including the concern that you just had, the comment you just had about the difficult nature of charging. And I think they actually included a footnote, not a footnote, but actually actually a paragraph from former Chief Justice Toll that talks about that from, in fact, the Fletcher case, which the defense actually referenced earlier. So all of that is in the Martucci case, which is the case that I handed up.
And so, our position with that is even if there is relevance, even if Your Honor finds there's probative value, it still, as Your Honor knows, has to be weighed against its prejudicial effect. We argue it's substantially outweighed by its prejudicial effect, given the fact that there's no further evidence as far as, again, exactly how that had affected. That's our position,
Yeah.
given that it's not a homicide by child.
Yeah, I would expect that to be your position.
Coupled with the fact that they don't know, it's on video, as Your Honor must be aware by now. The child is on video being carried, placed in the car, closed the doors, walked away. It's not disputed. It's not somehow worse if someone is positive for methamphetamine and does that.
Maybe
It's
they
just
were
prejudicial.
sleeping inside for 6 hours or 8 hours or whatever.
Why not if they're doing methamphetamine?
Well, I don't know. What kind of information is the jury entitled to know about this unexplained death?
It's explained. I mean, we can stipulate to the cause of death, which is one more reason we don't need the photographs that were there earlier. I mean, the cause of death is, again, I speak for counsel without conferring. I think it's beyond dispute.
All right.
That as a solicitor stated, this child basically.
Okay. So, all right, what other issues do we have?
Based on the solicitor's firm statement, as far as the statements that they're planning to seek to admit, we get clarification, solicitor's firm. So for defendant Pangalangan, there's only one statement that the state seeks to admit at trial. Is that fair to say?
The judge, as I told you earlier, there are two statements. One is by her at the scene, which says, I went inside, I put the child in the car, I went inside to get cigarettes, I came back out, and we had the keys were locked in the car. The statement from Mr. King was the 911 call that he made, again, at the scene. Neither one of them were in custody at the time.
All right.
I don't have an issue with 911 now.
Any other issues?
Did have a motion to prohibit opinion testimony, essentially where if you have essentially someone who's put up and they cross that level of testimony, of lay witness testimony, to giving actual expert opinion without being qualified.
Referencing a particular witness or type of?
Well, I believe what we have is with certain witnesses, sometimes they will be in a position where their testimony starts to bleed into opinion testimony. And again, I know based on your honest prior ruling, we'll address that once they come up to testify. I'll make sure that be extra diligent so we can address that in camera.
Okay. What else? What else for the day?
We also have the motion regarding redaction of evidence. However, based on the prosecution's position of what evidence is not coming in regarding interrogation videos as well as some other videos, we will confer with them regarding what videos they do plan, which I believe obviously is the surveillance camera. There won't be, I don't think this motion is proper at this time until I speak to them to know for sure exactly what they seek to admit. But if it's just the surveillance camera itself, there shouldn't be any major redactions. We did have some heavy redactions that would have been necessary for other videos, but it appears that won't be necessary to be addressed for the court.
All right. Any other issues before we come tomorrow morning and start with openings with the jury, preliminary instructions and opening statement? Anything else before that?
Not from the station.
No, Your Honor. No, Your Honor.
Okay, very good. 9:30 it'll be.
Thank you.
That's bull butter. As Ricky Watson would say. Well, yeah, the video says they apparently took her out of the car and put her back in and then left, possibly to go get meth. Got back, checked on her, went inside, came back out, left again. And we are going to go straight into this because they're about to start this. So I had seen, and I'm going to have to pull more of the documents later, because when I was looking, it looked to me like they were going to be tried together, and then it showed they're being separated, but now they're both. So I'm going to have to go look. I don't know yet. I'll have to pull all the documents when we finish up with this today, and I finish up with some other things I need to do. So we'll try to have all the information together for in the morning, but for some reason I pulled up the Colleton County Clerk of Courts, and I could pull up the list of stuff that had happened, or like the actions, but it's not letting me pull up the docket, like the actual documents that I can pull. And so I'm going to have to mess with it a little bit when I have time. I'm Every time that guy stands up, he scares me. Pangalagan. Let's see. They're both charged with murder, unlawful conduct towards a child, and criminal conspiracy. The conspiracy stuff was some of the hearings we were just listening to, or motions, I should say. 5 hours. I'm trying to look. Hello. I'm missing some of chat because I'm trying to look up stuff to answer y'all's questions. So if I've missed any of your stuff, I'm sorry. It's not because I don't love you. It's because I'm trying to answer your questions. Yeah, let me pin that. Currently waiting on press conference for to begin. Why didn't my comment show up? Pin message. Okay, there we go. All right, let's see. It looks to me like they should still be tried together. I don't see why they. Everything that I see as of now says that they're still supposedly going to be tried together. Trouble became a YouTube member.
What? Did we just become best friends? Yep.
Yes. Welcome to the family. We're glad to have you. Search. So for for the boyfriend, first appearance date, motion discovery, coverage, court proceedings, case file notes. Actually, you know what? Let me look for. There was a news dude who all right, let's see what we can find. Um, Oh, this is interesting. Look. This is so it says family member confirms Rita was mother of 13-year-old who died in a car Monday. Tearful pleas from family to judge during bond hearing. I swear, this whole time they've gone up there and 27 different people have messed with the microphone, but nobody's actually coming out. Let's see. So that was her daughter, who was okay. Well, this just took a turn. This is her daughter who was just pleading for. I mean, that was an old bond hearing, obviously, but this is her daughter who was pleading for her mom to get bond. And she was arrested for leaving her kids in a car a week after her mother was charged with murder for leaving a girl in a car. Investigators have arrested a woman for leaving 2 kids in a car a week after. I read that this happened, and I was like, no, that's probably not true. Guess it is. Ashley was charged with unlawful conduct of a minor, according to Walterboro police. Police responded Monday to the Walmart. It's always a Walmart. For a report of a baby crying in an unattended vehicle that was running with the windows up. At least it was running, I guess. Don't leave your freaking kids in a car, kids. Y'all, don't leave them in a car. Police responded. Okay, so the responding officer saw 2 small children in the back seat of a blue Suzuki with a busted out driver's side rear seat window covered with plastic. Okay, wait, hold up. So they were in the car and the back driver's seat window was busted out and covered with plastic? What? One of the children, a 7-year-old girl, was in the car with her 9-month-old sister. 7-year-old unlocked the door and told police their mother was inside the store shopping. Outside temperature 91 degrees with a heat index of 97, and there was plastic over the window. Are you freaking kidding me? And this is her daughter, and this is a week after her mom gets arrested for murder for this? Yes, I will. For those asking, I will be live in the morning. We will be live for court in the morning. The incident report states that Central Dispatch confirmed the outside temperature was 91 degrees, and she left a 9-month-old and a 7-year-old in the car. It was also noted that even though the air conditioner was on, the vehicle was blowing warm air. Are you freaking kidding me? The report states that after approximately 15 minutes, how do you say it? Pangalangan, the lady, was spotted coming out of the store with merchandise and went to her vehicle and then came over to the officers and asked about her children. She told police she was only inside the store for approximately 5 minutes. However, officers had been on the scene for approximately 15 minutes at the time, the report says. An EPC was done on both children, and she was arrested for unlawful conduct of a minor. Ashley's mother, Rita, and Rita's boyfriend, Larry, were charged with murder and accused of leaving. See, they keep messing with that microphone, but ain't nobody going up there. Charged with murder and accused of leaving Rita's 13-year-old disabled daughter in a vehicle. Investigators say Cristina, that's the 13-year-old, died after she was deliberately left in the vehicle on August 5th. Investigators said at 11 a.m. on August 5th, Rita and King placed the child in the vehicle. The woman checked on the child at 12:15, and then when she went to check on the girl again at 3, she found the vehicle's doors were locked, according to authorities. I mean, a week later. A freaking week later. Report states that Rita and Larry left the home to get a spare set of keys. Authorities reported when the suspects returned at 4:15, the child was dead. Of course, now this was done a week after that, but of course now we know that that story is apparently disputed because of the cell phone footage that says something totally different. I don't get it. A week later. How is that a thing? Oh, look at this. Here's the emotional video after Colleton County woman Rita whatever charged with murder for death of 13-year-old girl with special needs after police say girl was left in the car. So this is the Oh, we got slow-mo. Sounds like our aliens. And so Ashley, her daughter who got arrested for leaving her kids in the car a week later, said that losing her daughter is punishment enough. She'll have to live with that. I don't think losing her daughter is punishment enough. If she did that, if she really did do that on purpose, and we'll find out all the, details, but if she really did do it on purpose, then losing her daughter is definitely not punishment enough. If it was a tragic accident, but then again, I mean, there was meth in her system and in his system, so automatically that, I don't get it. I don't know. Oh. They're just never going to show up here.
Hey, Scott, we're not sure. No? Are you on IP? No. Okay, we're on IP. Hey, Scott, we don't know yet. I'm not sure when it's going to start.
Yo, and bad catch you with
Whoa.
another.
What is happening? Oh.
I think it may be too close, Scott. We could start it if we didn't. Like they could walk in any minute.
I don't know. Something on one of my other screens just started to play. So it was all of a sudden voices. I don't know. I don't think so. I think they're here. They're lurking. Ominous hand. If you're watching, give us a peace sign. What'd you do if they really did like be like, oh my gosh, I knew it. Let's see if you can zoom in on that lady's phone and see what she's looking at. She's texting. Scrolling Facebook, Instagram, Twitter, texting. All right, let's see. This was supposed to start like, what, 30 minutes ago? Hour ago? Something. All right, here we go.
All right, hello everyone, and thank you for your patience as we work through today's events. My name is Kevin Best. I'm the Senior Director of Media Relations here at Chapel Hill. We have a number of folks here with us, and a few of them will take a few of your questions and discuss today's incident. We have University of North Carolina Chancellor Kevin Guskowitz, UNC Chief of Police Brian James, Chapel Hill Police Chief Salisa Lehue, Orange County Sheriff Charles Blackwood, Commander Freddie L. Johnson Jr. of the North Carolina Highway Patrol, Secretary Eddie Buffalo Jr. of the North Carolina Department of Public Safety, Special Agent in Charge Bob DeWitt of the FBI, Orange County District Attorney Jeff Neiman, and UNC Board of Trustees Chair David Bolick Jr. We know there'll be a lot of questions and we'll take a few, but please understand this is an ongoing investigation and questions will be limited. We'll start with Chancellor Guskowitz.
Thank you all for being here today. This is truly a tragic day for our campus community. Chief James will give more details on the ongoing investigation, but this afternoon, shortly after 1 p.m., UNC police were notified of shots being fired in Cottle Laboratories on our campus. The suspect was eventually apprehended and is now in custody. I'm grieved to report that one of our faculty members was killed in this shooting. This loss is devastating, and the shooting damages the trust and safety that we so often take for granted in our campus community. We will work to rebuild that sense of trust and safety within our community, and our hearts are with the family of our fellow faculty member, those who are personally connected to the victim, and those traumatized by this senseless act of violence. In response, we have canceled classes for the rest of today, canceled classes for tomorrow. We've sent an email with resources for our students, faculty, and staff. More information will be provided on additional services for our campus community. I'm grateful to our Emergency Operations Center, UNC Police, for managing this situation so effectively and keeping our community safe. I'm also grateful to our faculty, staff, and students for their effective cooperation during this event today. It's why we have an emergency action plan with an active shooter protocol that's practiced regularly, and because of that, this situation played out as best as we could have asked for today. I hope that you'll join me in praying for the victim's family, and every member of our Carolina community. And I encourage our community to come together during this difficult time. I'm now going to turn it over to Chief James to give you additional details on what happened today and his department's impressive response in keeping the rest of our campus safe. And I also want to thank the other law enforcement agencies, many of whom are here today, for the role that they played in keeping our community safe. Thank you.
Thank you. I'm Brian James. I'm the Chief of Police for the UNC Police Department. I thank you for being here this evening. And thank you, Chancellor Guskowitz. I also want to offer my sympathy to the victim in this incident and express my empathy to the entire UNC and Chapel Hill community. I'm very sorry to be standing before you today in these circumstances. It's a day we train for, but we hope it never comes. I know there will be a lot of questions as we try to answer as many as possible, but please understand this is an ongoing investigation, and there are many questions that we will not have the answers to at this time. I want to start by confirming, as the Chancellor did, we do have the suspect in custody from today's active assailant incident. At this time, we are not releasing the name of the suspect, as formal charges have not yet been filed. We are committed to conducting a thorough investigation, and we will provide as many updates throughout the process as we can. The FBI is providing assistance with multiple resources, including victim assistance and the evidence response team. The Cottle Lab, which is the location of the incident, will be closed until further notice as evidence is being processed. We want to ensure that we gather every piece of evidence to determine exactly what happened here today and why it happened. It is too early in this investigation to know a motive for the shooting. We will be working with all the law enforcement agencies you see represented here to uncover every fact available. That will take time, so we ask in the meantime that you continue to express your warm thoughts to the UNC Chapel Hill community. This investigation will continue for several weeks, but here's what we know right now. UNC Police received a 911 call at 1:02 p.m. this afternoon reporting shots fired at Cottle Laboratory, located on South Road in near the center of campus. An emergency alert Carolina was issued, and the emergency siren sounded at 1:04 p.m., notifying campus of the emergency and issuing a lockdown. Upon arrival at Cottle Labs, police discovered one individual, a faculty member, had been shot. Unfortunately, as we have reported, this person is deceased. We will not be releasing further details on that person at this time, as we are working to contact all of this person's family and will be providing them with support and resources. This is the only fatality and no other injuries were reported. Based on witness information at the scene, UNC police were able to identify a suspect, and after a search of the surrounding area, this suspect was taken into custody at 2:31 p.m. The lockdown of the campus remained while police verified the suspect's identity and conducted a comprehensive search for the weapon that was used in the shooting, which at this time has not been located. I want to thank all the law enforcement agencies who responded to assist today. Their assistance was invaluable, and we could not have responded so quickly or so thoroughly without their help. So at this time, I'll turn it back over to Kevin, and I guess we'll take any questions.
Yeah, at this time, like I said earlier, like you said, we'll have a few questions that we can take. Obviously, ongoing investigation, only some of the things that will be discussed, but if you have a question, please raise your hand. I'll point to you, identify yourself, and ask your question.
Stephen Schwenk, UNC South Carolina. We know that there is a car in the new medical parking lot. Please state confirm to us that does have some sort of correlation to this event. And also what kind of correlation that has.
Yes, a car was identified. We do think that it is related to the investigation. As we said, we are still in the process of collecting evidence and conducting interviews, so I'm really not prepared at this time to say exactly what the connection is, but we do have that car identified as a piece of possible evidence. Yes, sir.
The front row here.
Yeah, so we heard from talking to students that they had to come during the day because between the time that the suspect was apprehended and the time that the volunteer went out, that was about 2 hours, and students were being evacuated from some building before then, and said that they weren't really sure what to do next. Can you speak to the communication during the process of why that all ended so long?
Yes, so once the suspect was identified and apprehended, we still had to ensure that this was the correct person. So there was an identification process. We did not want to put that information out at that time because we weren't sure. Also, we were receiving a number of calls around campus about possibly having other victims. There were a couple of other calls about possible gunshots. So we had to ensure that the entire campus was safe. So we had a number of officers that were on the ground doing an entire sweep of that area, also searching all the adjacent buildings. So we wanted to be sure that that the campus was in fact all cleared before we issued that. So that's why there was the lapse in time. We just wanted to be sure that we had that person in custody and it was the correct person.
Can you tell us the suspect and that member was killed? Were they known to each other? Did they ever work together?
We don't know that information at this time. That'll hopefully be uncovered through interviews of the suspect as well as
She asked if the
witnesses that may be available.
victim and the suspect knew each other.
This is really a time for the community to come together, and these tragic events sadly are happening across our nation. And again, it's why we prepare and talk about a sense of community. And so right now, that's what my thoughts and prayers are with obviously the victims, the victim's family, and friends and colleagues and students who are part of that department. And so we hope our students will access the resources we're making available and come together in a really important way for the campus right now.
Who's an observer? Can you tell us about how the suspect was apprehended, where exactly he was apprehended, where tips came in, reports?
So we did a comprehensive search of campus as well as surrounding areas. So at this point, I am not prepared to say how he was apprehended, but we are sure that it's him, and we were able to verify that.
I spoke with several students, one of them, Mrs. Chancellor. She had said that the faculty had essentially told students to make personal decisions on what to do next. She had said that she was in the closet, a lot of people calling their parents saying goodbyes. I know you had mentioned that there is an active shooter kind of protocol in place, but it seems that some of that maybe got lost in the today. And I know this is a scary kind of incident, but what is that protocol?
Again, I'm very pleased with how the protocol was carried out today. I had a chance to go over, along with the provost and others, to talk with the faculty who were there in the building at the time of the shooting, and some of the students, and they're certainly traumatized, but I want to commend those who were in the building, ensuring that they were doing everything possible to ensure the safety of those students and faculty and staff that were in the building. So again, even the best laid plans, as you know, and protocols, sometimes they don't play out as you'd like to, but I'm very pleased with what we know at this point. We'll have an opportunity to review that, learn from the investigation and questions that are being asked, and certainly put improvements to that if need be.
Yes, how helpful is it to have the suspect alive?
I can't hear anything they say.
Well, we certainly want an opportunity to interview the suspect if that's possible. And to actually have the suspect in custody, it gives us an opportunity to figure out the why and even the how, and also helps us to uncover a motive and really just why this happened today. Why today? Why at all? And we want to learn from this incident, and we will certainly work to do our best to ensure that this never happens again on the UNC campus. And I think that that information that we could glean from the suspect is very important as we move forward.
Oh, okay, you said you're looking for a weapon. Is it a firearm? Do you know what type of firearm? Is it too early to tell if the suspect has legally obtained a firearm?
We are looking for a firearm. It is too early to determine if the firearm was legally obtained, and not prepared at this time to say exactly what kind of weapon it was.
There were reports earlier this afternoon about possibly some other suspect being taken into custody. Is that an error? Can I talk about that?
Yes, so there was another person that was detained, and we determined very quickly that that was not, in fact, the suspect.
Can you tell me what criteria led to that arrest, and then let go of that person as a suspect, and why that was taken, and how?
That was based on just the description that we were given of the suspect and that person being in close proximity of the incident.
I know you said you guys are looking to speak to the suspect to try to ascertain the motive, but is there anything that you can share at this time as to what might have led to this?
We really don't know until we speak with the suspect. That's my best answer I can give you now. We really do want to know the why in this case and what led to it.
The last update we have, we'll only take a few more questions over here.
We have some students right here in front of there's thousands out there who want to hear from you today. What can you tell them directly? Help us speak about it.
First of all, I'm sorry because I know so many of you are feeling uncertain about your safety right now. And again, we have very good protocols in place. There's nothing more important on our campus than the safety and well-being of our community members, and certainly our nearly 30,000 students are at the top of that list alongside our faculty and staff. So we're here for you. I'm pleading with you to use any of the resources that you may need, and we'll come together as a community to ensure your safety and the safety of anyone who visits our campus here at Chapel Hill.
Chancellor, can you specify what kind of training faculty and students get when it comes to specific bad situation? Can you elaborate a little bit on that?
So we have an emergency action plan, and active shooter training is part of that. And so we, about a year ago, we rolled out a program by which, and I'm going to ask Chief James to say a little bit more about it, along with Daryl Jeter, who I know does an incredible job of running our emergency operations center. And there are specific guidelines provided to faculty for the specific classrooms and laboratories in terms of how to go about doing this. Now, it's every classroom, every laboratory, every auditorium is slightly different in terms of how you would lock down a facility, but we're doing the very best that we can. And again, I'm proud of the fact that our emergency operations center took this very seriously, learning from some of the tragedies that have happened on other campuses, and we all have to learn from one another. But Chief may want to say a little bit more about the specifics.
So the primary purpose of the emergency action plan was to ensure that every faculty member, as well as student or staff, understood what to do in a case like this, such as an emergency lockdown or an active shooter. Another layer that we've done from the University Police Department, we've done a number of security surveys across campus to find out how to better secure various buildings on campus. As you know, the buildings range in age on this campus. And so each building can be very unique in how you actually lock it down. So it was important that every member of the organization of UNC assigned to those various buildings understands how to lock down a classroom or any type of structure that they're in, and know where the best places are to go in case of a lockdown. So we've worked very diligently to ensure that that information is out there, and we'll continue to work on those efforts.
All right, thank you, everybody. Like I said, we'll have more information throughout the next few days, but thank you everybody for coming. We'll have updates as we can.
I wonder who they are. They made a special point to go speak to them. Goodness gracious. Sad, sad, sad. Alrighty. Well, that does it for today. I will be back in the morning. We have, y'all, it's going to be a sad trial. It really is. It is going to be a sad trial. But man, am I looking forward to having Judge Newman. Oh, there's RA. We were just talking about that, RA, that you were in Chapel Hill. It's crazy. It's crazy how just how fast things can happen, and you really just never know. It's insane. So, thoughts and prayers with the family of the victim. I can't even imagine. Sad stuff. All right, I am going to call it a day. Oh, Jen.
What? Did we just become best friends? Yep.
4 months of being best friends, Jen. We are glad to have you here. I have to run to the post office and run a couple errands and take Miss Lucy Girl out. We will be here. Judge Newman will be here with us in the morning. They are having the jury come in, or I think they said 9:30 in the morning is when they're having jury come in. So we'll start a few minutes before that. It'll be about 9:15 Eastern that we'll start in the morning. So that's 8:15 Central here where I am. And we will watch what happens. Duffy Stone is on this one too. So a lot of familiar South Carolina names for those of us who have watched, the whole Alex Murdaugh saga from the beginning. So it starts at 9:30 Eastern, so we'll be here about 9:15 Eastern. And tonight we should be having night court as well. I haven't heard otherwise, so I'm assuming we are. So night court will be 8:45, 7:45 Central tonight here as well with JT and Jody Arias and all that fun stuff. So, so that's all I got for today. Lucy would tell you goodbye, but y'all see she's super busy right now, like super busy, doing absolutely nothing, being a lazy little bum, that one. All right, if y'all are in the path of the storm, be careful. If you are, oh, now she's awake. She's awake. She's awake. Hi. Hi. She's like, wait, are we about to go out? Are we about to go out? Wait, I'm up. I could be up. I could be up. I could be ready. Look at that face. Look at that face, that bedhead. All right, I will see y'all either this evening at night court, 8:45, 7:45 Central, or in the morning, bright and early with Judge Newman. Bring your dozen eggs and don't be late. I will see y'all then. And she's back down. All right, y'all. I appreciate you showing up. Thank you for reporting to jury duty. I will see you in the morning.